All right, let's get started this morning. Well, welcome everybody. I'm Mickey Savage. I am the president of the Michigan Association of School Personnel Administrators this year. And thank you for being here and joining us this morning for our legal update. This morning we have with us Robert Schindler, better known as Bob. Many of you know Bob. And Bob, thank you for being here and being willing to share your expertise with us this morning. A little bit about Mr. Schindler. Bob is a graduate of Eastern Michigan University and Michigan State University College of Law. He has successfully represented public school clients in both state and federal courts, as well as before administrative agencies. Bob has become known throughout our state, not just as a school law attorney, but as a speaker, author, and a teacher. As well as in this regard, he speaks regularly on education law and labor and employment topics to school districts and professional organizations. Bob is also an adjunct professor at Oakland University. And just a little bit of personal, education has long been a passion of Bob's, as he began his professional career as a secondary level social studies teacher and a coach. He's also an avid skier, cyclist, and a fan of Detroit and Michigan State sports. Go Green. His biggest passion, however, is his wife Danielle and their 4 children, with whom he resides with in Beverly Hills. So thank you, Bob. We appreciate you always being a good friend for the MASPA family, and we'll let you get started this morning.
Thank you, Mickey. I appreciate it, and I always enjoy speaking with MASPA. Hopefully it looks like we're maybe getting to the time here in the not too distant future where we can actually see everybody in person and have these conferences again. I'm looking forward to those days, and we can do that. Good morning, everyone. During the course of this, as Mickey mentioned, today I'm doing a legal update. We're going to talk in a few minutes about what we're going to be focusing on. During the course of this presentation, if there are questions, please feel free to put them in the chat. As we have breaks in between topics, I'll try and address any questions that come up. Hopefully we'll have some time for question and answer at the end of the presentation as well. If you want to hold on to your questions, either way, but please feel free. I always enjoy interaction. It's not quite the same again as a live audience in that interaction, but if you have something that you think needs clarification or you want to discuss, feel free to let me know. All right, I'm going to turn off my camera so we can focus on the presentation, and we're going to go from there. All right, first, just remember, I am a lawyer, but I'm not necessarily your lawyer. So and this is not me giving legal advice, if you have questions that come out of this, give me or somebody else a call and get more detail. So what are we going to be talking about today? Well, one, we're going to focus on, it's a legal update. So I want to talk about some state and federal cases of major significance that affect Michigan public sector labor and employment. I'm focusing, again, this is MASPA, I'm focusing on labor and employment cases. There have been a lot of updates related to COVID. You've probably heard of this COVID thing that's going around. But I'm going to stay away from that. There are seminars upon seminars talking about COVID. So I want to focus on more HR and labor stuff, and that's what we're going to be talking about today. So it's going to be state and federal cases. We're going to talk about some decisions of the Michigan Employment Relations Commission that have come out within the last year that are important for us. We're going to talk a little bit about the U.S. Department of Labor issued a independent contractor rule during the last administration, which has now been withdrawn by the current administration, federally talking about. So we'll talk about the significance of that a little bit. We'll also talk about some new EEOC religious accommodation guidance and what that means. We'll try and tie it in a little bit to what's been going on a little bit with some case law as well. And so we'll talk about that also. All right, so federal cases, we have a few of them. Title VII violation, for example, ministerial exception and First Amendment retaliation. A couple of big ones that have come out of the U.S. Supreme Court. First, we're talking about the case called Bostock versus Clayton County. This came out last summer, and it was a fairly significant case. An employee was terminated. Actually, it was several cases combined. Employee termination cases combined. One was terminated after joining a gay recreational softball league. Another was terminated after he mentioned he was gay at the workplace. And then the third, and maybe one of the more significant, I know from a school standpoint, was an employee who originally presented as a male, when hired, subsequently terminated after she informed her employer that she planned to live and work full-time as a woman. So all of these cases were combined and headed up to the U.S. Supreme Court. So the question that came up is, does an employer violate Title VII, which is a civil rights statute that includes anti-discrimination based on sex? Does it violate Title VII when it terminates employment because the employee is homosexual or transgender? So what did the court hold? Supreme Court held that an employer violates Title VII when they terminate an employee based on their sexual orientation or transgender status. This case was a bit of a surprise for some people, in part because it was authored by Judge Gorsuch, who of course was the first appointee of President Trump, and he authored this decision. And in the end, the court voted on a 6-3 vote. And what they said, there's a quote here from the case: an employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex, therefore, plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. So, one, this case is not in the educational context, but I think it's one that we can obviously understand the importance to in the educational context, in that Title VII and its standard of discrimination based on sex is the same standard essentially that's in Title IX. So from a school standpoint, that's an important statement when all of a sudden when the court says that discrimination based solely upon transgender or sexual orientation, transgender status or sexual orientation is discrimination based on sex. Next case is a case called Meriwether versus Hartop. This was the Sixth Circuit Court of Appeals, which is the federal appeals court that covers several states, including Michigan, meaning decisions that come out of the Sixth Circuit are binding on federal courts in the state of Michigan. So in Meriwether, there was a professor who objected on religious grounds to university policy requiring employees to refer to students by their preferred pronouns. So this is a brand new case, just came out in March. Again, professor or university says that if a student, that professors must refer to students by their preferred pronoun, this professor refuses and objects on religious grounds to do so. He seeks an accommodation from the university based on religious grounds, and the university refuses to give him an accommodation. Eventually, the Title IX office ends up conducting an investigation after receiving complaints from a transgender student about the way the professor was referring to the student in class. A written warning was placed in the professor's file for creating a hostile environment for the students. He alleges, and the professor sues, alleging that the written warning, the discipline, is a violation of his free speech and free exercise clause of the First Amendment. And so the court looks at this and determines that, one, the First Amendment does protect the academic freedom, academic speech, academic freedom of university professors. The court also finds that the university was hostile toward Meriwether's religious request for accommodation, and the policy was not neutrally applied to religion, and therefore the professor wins. Now, this is a really interesting case. So what does it mean for K-12? Well, there's a couple of things at interest here. If we go back to that Bostock case from the U.S. Supreme Court, in Judge Gorsuch's opinion, he specifically talks about the fact that there could be implications of the Bostock decision to academic freedom, but because they are not at issue in that, they were not at issue in that case, the court wasn't going to get into them. So, that's one important piece. Two, it's also important to understand that the concept of academic freedom really is a university concept and not a K-12 concept. So when it comes to, at least from a case law First Amendment standpoint, many of you or some of you may have, for example, academic freedom provisions in a collective bargaining agreement. I've seen that plenty of times out there when reviewing CBAs. And that would be a contractual benefit, but K-12 teachers don't have academic freedom in the sense that university professors do. So I do think that there is a limitation for the application of this case, at least from the free speech context at the K-12 setting. But where I do think this is going to get interesting is in this free exercise argument. And I say that because what we see is we have a Supreme Court right now that is very accommodating to the argument of religious freedom. And in some ways, religious freedom being used in a different manner than legally it has in the past, which is to say that placing it more in an individual context and allowing people to refuse duties and things based upon their own religious preference within secular environments. And this is an example. Now, in this case, if you read the facts of the case, what the court focuses on was the way the university treated this guy when he came and asked for accommodations. He was sort of scoffed at. He was treated poorly by his administrators for even, sort of bringing up the notion that this could offend his religious sensibilities. And as a result, that's really what the court focused on, not necessarily even the actions of the policy itself or his actions in the classroom. It was focused mostly on their hostility toward him and his religious beliefs. So that's something else to consider. But I do think over the next several years, this is going to be an issue that we're going to see sort of the give and take on, because we have the Bostock decision that says discrimination based on sexual orientation and transgender status is sexual discrimination. But we also have more and more case law on the religious freedom concept and individual actors within a system and what they're required to do. So I don't have an answer for you yet, but I think this is going to be an issue that is going to become one that we're going to see down the line, and we're going to have to deal with a bit. All right, Trinidad versus School of the City of East Chicago. This is a Northern District of Indiana case, so it's a federal case. It is not a case within our circuit, our jurisdiction. So again, I just talked about the Sixth Circuit Court of Appeals. Indiana is in the Seventh Circuit. So cases out of Indiana and out of the Seventh Circuit aren't binding on courts here, but of course they can be can be used in courts and can help us guide and see where cases are going. So in this case, a paraprofessional named Trinidad smelled a chemical odor. Trinidad informed the principal, and then, because it's 2021 or 2020 in this case when he acted, had to go to Facebook with it, right? Because nothing really happens unless it's on social media. So he goes to Facebook and posts, "Attention, if you have children attending McKinley School, please be aware there is a terrible chemical odor lurking throughout the building." I love his sense of style on this one. Many children and staff had gotten sick. Vomiting, dizziness, and headaches, burning eyes, and achy chest are some of the symptoms. So, as you can imagine, this creates a bit of an uproar, and is also a situation where school administration is not very happy with what he did. The district ends up suspending him for 5 days with pay and instruct her to remove the post. Later on, she's transferred from elementary to high school, then later assigned to work with preschool children, and then eventually back to the elementary school. She files a grievance under the CBA, files a lawsuit against the district alleging retaliation in violation of the CBA and her First Amendment right to free speech. Now, for those of you who have, I know I've talked about this at plenty of presentations before, and you've probably sat through others as well who talked about the First Amendment and what it means, First Amendment and social media, and we're still sort of figuring out all the details of this. But generally, an individual who's employed by a public agency still has First Amendment rights, and so in order to win a case under First Amendment retaliation, the employee must prove that their speech is protected by the First Amendment, that they suffered a deprivation likely to deter protected speech, and the deprivation was at least partly motivated by the protected speech. So when we look at what is protected speech, one, we have to look at whether the speech is being made as a citizen or as an employee. So was it made pursuant to their job duties? Was it made on the job? Was it made as part of their job? That sort of thing. Does it address a matter of public concern? And if those two things are met, then we look at whether the employee's interest in expression outweighs the state's interest as an employer in promoting effective and efficient public service. So, in this case, the court dismissed Trinidad's CBA claim because under the CBA there's a grievance procedure, and what the court said was the federal courts are not a place for a grievance under a collective bargaining agreement, but the court ruled that her Facebook post was not made pursuant to her job duties. So that's a big first step, right? Again, you have to be speaking as a citizen on a matter of public concern. And what they said here was that she was, even though the post was about school, her post was not made pursuant to her job duties. It occurred outside the workplace. She posted it outside of work hours. It was not posted by a district managed account or one associated with the district. And while the post was about workplace conditions, not her personal workplace duties. The court eventually found that the district failed to establish that her statements were false or that she acted with reckless disregard of the truth because the district never investigated the odor. And the court eventually determined that a reasonable jury could determine that the suspension and transfer were made in retaliation of her exercise of free speech. So when it comes to that, speaking as an employee on a matter of public concern, or a citizen on a matter of public concern, what they said was, well, this is a matter of public concern. It's the condition of a school. And at that time, she was not speaking as an employee. It was outside of work hours. It wasn't a work account. And she wasn't just sort of talking about her duties, but the general conditions in the school, which are a matter of public concern. So, we get the calls all the time about Facebook posts and about Twitter posts and what can we do and what should we do. And so this is one to show, I think, and courts are starting to get more and more into some of these cases. This is one where we have to look and we have to think about the fact that just because a Facebook post is by an employee and it's about school doesn't mean that we can say, okay, the citizen on a matter of public concern thing does not apply and we can do what we want with it. While this person was not disciplined for the post, their assertion was that the transfers were in retaliation. The court didn't say that they were or they weren't. What they said was, well, it's reasonable for a jury that they could potentially determine that there was a suspension, the 5-day, I forgot about that, but that the suspension and transfer were in violation, and therefore it had to go to a jury to make that decision. All right, so those are the federal cases we're going to talk about today. Let's move to Michigan cases. All right, first one we're going to talk about is Tecumseh versus Michigan Department of Education. So this is one that went to the Court of Appeals, but I know that we've dealt with several issues with MDE and administrator certification over the last few years. And this is one that helps us understand some bounds and give a bit of a warning as well on it. Case was decided initially by the Ingham County Circuit Court in January of 2021. In this case, the school district Tecumseh hired Lewandowski in '97 to serve as principal. At that time, he had applied for his administrator certificate in January of he applied in January of 2019. MDE issues a certificate in April of 2019 once he submitted all required paperwork. MDE sent a letter notifying the district it would be imposing a state aid deduction of roughly $67,000. So, as you may know, under MCL, Michigan compiled laws 380.1246, a school district cannot employ an administrator unless A, if the administrator was hired before 2010, the administrator completed certain continuing education requirements, or B, if after 2010 they hold a valid Michigan School Administrator certificate. In this case, the district appealed the decision and sought to appeal to the circuit court. According to the court, the administrative code clearly mandated a minimum of a total of 150 hours in the 5 years prior for those individuals hired before 2010. Because Lewandowski had not provided any supporting documentation relative to his participation in continuing ed, totaling 150 hours in the prior 5 years, he was in violation of this requirement of employment, and a state funding deduction was imposed against the school district after it employed the administrator lacking the prerequisites for an administrator's cert. So as far as what can we learn from this case, I think it's probably important that you need to do an internal audit and make sure that all of your admins meet the requirements for an admin cert if you haven't done that already. When you're hiring, ensure you are employing administrators with valid and updated certificates where required, and remain in compliance with all relevant statutes and rules. In this sense, I know we've seen it, for example, with, one of the difficult areas can be if you're hiring somebody from out of state, for example, and making sure that you get the application materials in and take care of that right away, so that you don't get hit with these administrator cert problems. Have a system in place to continue to monitor certification validity. One of the differences in when it comes to teachers, for example, we always we always put that on the teacher, right? It's their responsibility to update and maintain their certificate. And when we find out they aren't, well, generally that means there's no more protection when it comes to tenure. That means they can be discharged, so on and so forth. When it comes to administrators, it's a bigger issue for us because it's not just about the fact that these CERT problems, but it can truly mean a lot of money because they're going to give you a state aid deduction in the process. So you need to be careful of that. Question came up in the chat box. What is the name of the certification case? Again, going back, that's Tecumseh Public Schools versus Michigan Department of Education. All right. Next case, Davis versus Jackson Public Schools. This is a Michigan Court of Appeals decision that came out July of last year. In this case, the teacher, Davis, was rated highly effective for the 14-15 school year. In 2015, Davis alleges that she was assaulted by a student, MH, and she goes and obtains a PPO against the student. After Davis attempted to amend the PPO following in-school concerns, she was transferred to the district's IB school. So if you read the facts of this case, what Davis says is that she was transferred, well, the student was violating the PPO, coming close to her at one point. I think she says, she alleges that the student came to her classroom door, knocked on the door. So she goes to amend the PPO. The school district then says, okay, we're going to separate the two of you and we're going to transfer you to the district's IB school. She asserts, well, I wasn't properly trained for an IB program, and you were doing this in retaliation. Once she goes to the IB school, her performance was substandard, and she was placed on an IDP. From the facts, I couldn't tell if she was rated ineffective or minimally effective. The court is not as precise as we educators are in terms of using terminology, but at the very least, she was less than effective and was placed on an IDP. Oh, sorry. Someone asks, what is an IB school? I'm sorry, and I apologize. This is one of those, throw out an acronym, and I make assumptions that are not always good. IB means International Baccalaureate School, so it's an international school. So it has a whole different IB program, and has there is a certificate program that comes along with an IB school, an International Baccalaureate School, and it has a very defined curriculum involved. So she's placed on an IDP. She files a lawsuit against the district, claiming they retaliated against her for reporting the assault to the police, and she claims a violation of the Whistleblower Protection Act. The Whistleblower Protection Act says that you cannot retaliate against someone for reporting a violation of law. In this case, the district seeks to have the case dismissed. The judge denies it. It goes to trial. There's a jury award. District later then appeals, claiming a few things. One, the judge should have actually dismissed it. It shouldn't have gone to the jury. And then in the end, that Davis couldn't show a causal connection, a link between her contacting the police and the transfer. So the Court of Appeals ends up affirming the jury's award, or affirming the judge's decision, and rejects the appeal. The court found that Davis, at the very least, provided sufficient evidence that she had been treated in a highly unprofessional manner following her contact with the police. Again, this is not a statement in terms of what the district actually did. This is really a statement of whether there's evidence that the jury could have found this. The district argues that, hey, it transferred Davis to comply with the PPO, but the court found that the teacher presented evidence that the district's reason was not actually because of the modifications in the PPO, because the transfer happened in between the time that she filed for the modification of the PPO, but before the modification was actually granted by the court. So the Court of Appeals says, well, that couldn't have been the reason, essentially, because of the fact that the modifications hadn't actually been made yet. So I think one of the lessons, out of that case is, when those situations happen, it's always difficult, right? And we've dealt with this before, where you have harassment allegations or assault allegations between either co-staff members or staff and student, and you have to move forward in a manner in which you try and protect the parties. And sometimes the parties aren't going to agree with your decision-making process there. So there's a lot to think through in those situations and how to move forward. And it is one where I think, not just a plug for lawyers, but when you have those scenarios, that is one to talk through with your lawyer, because it very well could come down. Normally, when you're going to transfer somebody, whether it's a student, whether it's a staff member, oftentimes they don't like it. They feel as though they're being punished for the process. And so it's something to really think about. Okay, Harlan versus Detroit Public Schools Community District. This is a Court of Appeals case. In this situation, the Harlan, who was a teacher aide, again, we have an allegation of a student assault. Here, Harlan was placed on leave, and an investigation was done claiming that she falsified the reports of the assault. An investigation was launched and recommended that Harlan be suspended for 3 days, claiming that she did, in fact, falsify the claim. The school district terminated her, Harlan, not Harland, responded by claiming that the district violated the Whistleblowers Protection Act when she was discharged. Now, this is an interesting case, because what the Court of Appeals finds is that they agreed that Harlan engaged in protected activity and was terminated because of it. In fact, in this scenario, what they say is, well, district administration even testified, I believe in deposition, that yes, she was fired because of this report and the fact that we believe the report was falsified. So what the court found was, well, that report is protected activity, and she was terminated because of it. So there is a causal connection between the two. And what they say is, essentially, the court, this matter should go to a jury, because there's a factual conclusion as to whether or not the report was falsified. In this case, there was video, for example, that shows that the student had brushed into the teacher. The district's assertion is that the paraprofessional, that the paraprofessional's account of it was clearly false. And what the court says is, well, it's a close enough call that this needs to go to a jury. So it's an interesting case, because in the end, the basis of the discipline needed to go to the jury, even though if the district is correct and she did in fact falsify it, well, then that eliminates the Whistleblower Protection Act claim, and the district wins. But then there's the question of fact as to whether or not it should be heard. Jewett versus MASPA Consolidated Schools. Again, another Michigan Court of Appeals case. This one is issued in March of 2020. In this case, a custodian suffered from ADHD, a reading disorder, and other conditions. He had a long history of disciplinary problems and subpar performance. District sought to enter into a last chance agreement with him, and instead he says, "I'm not doing that," and he resigns. He then files a lawsuit against the district, alleging he had been discriminated against based on his disabilities. Court finds he was not discriminated against on the basis of his disabilities, and in fact, he was actually accommodated for many years, and as a result, there was no constructive discharge. And so, a couple important concepts here, right? So, constructive discharge is the idea that he wasn't actually fired, but that the average person wouldn't continue to work in those conditions. That's what a constructive discharge means, is even though I quit, the conditions are intolerable, and as a result, no average person would have sat there and continued to work in that condition. And the court said, no, that isn't the situation here. There is no constructive discharge. And as I mentioned before, they also went through and talked about the idea that, the district made accommodations for him. For example, school staff had written materials for him, had read written materials for him because of his reading disability when necessary. His job responsibilities were communicated to him either verbally or in color-coded building illustrations, etc. So they had actually been making accommodations for him, and as a result, there was no discrimination. This was a performance issue, and there was no constructive discharge. Black versus Bogner. This is a case that deals with governmental immunity and protection for school district superintendents. This is a Court of Appeals case, unpublished in October of 2020. A case I know well because I've handled it, but in this case, the superintendent met with an assistant superintendent to let the assistant superintendent know that she'd be recommending him to the Board of Education for discharge and non-renewal of his contract. It actually wasn't a non-renewal, it was a discharge, although I think the court decision says non-renewal. The assistant superintendent gets upset at the meeting and protests the decision in a manner that is intimidating and frightening for the superintendent. Several months later, the assistant superintendent came back to the building and parked outside the superintendent's office prior to a board meeting when the superintendent was sitting in her office, and sends a text message to the superintendent while he's sitting out there in the car. The superintendent then files for a personal protection order against the assistant superintendent, now former assistant superintendent, because in the end, he was going to be recommended for discharge to the board, and the assistant superintendent resigned rather than go to the board. The assistant superintendent files a lawsuit against the superintendent, alleging that her statements in the PPO were false. Files a lawsuit asserting that the statements in the PPO are false. In particular, he says that he never sent the text message to the superintendent, that it was made up. And a motion to dismiss the claim is filed on several grounds. One is that the statements made to the court were absolutely immune and protected under a privilege for testimony, but also that as a superintendent, the superintendent is entitled under Michigan law to absolute immunity for essentially anything that's being done within the course of her employment, within the scope of her employment. And so as a result, she says the filing of the PPO was within the scope of my employment. The assistant superintendent says, no, it isn't. It's a personal protection order. And as a result, it's not for you as superintendent, it's for you as a person. So this is the language of the statute that actually, grants the protection under the law. And so there's no question that a superintendent is the highest appointed executive official in the school district and gets this absolute immunity. The question then becomes whether or not, by seeking the PPO, she was acting within the scope of her duties. The trial court dismissed the case on motion. The former assistant superintendent files to the Michigan Court of Appeals, and the Court of Appeals rules in favor of the superintendent and dismisses the case as well. And what the court finds, among other things, is that the filing of the PPO petition in this case was an act within the scope of her executive duty, and that governmental immunity applied. So in other words, just because it wasn't part of her normal day-to-day job functions does not mean that it wasn't within the scope of her duty. It was because both incidents that were the basis of the filing of the PPO occurred on school property. They occurred in the context of employment, and the protection being sought stemmed from her performance of executive duties, her performance of her job as a superintendent. And as a right, it extended those duties to that executive function, and immunity applied. This case is now currently awaiting application at the Michigan Supreme Court. Again, I know because I have some inside information on that one. We don't know yet whether the Supreme Court is going to hear the case or not, but we will see. The decision of the Court of Appeals is unpublished, even though this issue has never really come before the court before. So in some ways, we'll see what the Supreme Court does on it. But that's where that's at. Okay, so those are the Court of Appeals cases that we're going to talk about. Next, we're going to talk about some MERC decisions. So for those of you who don't know, MERC is the Michigan Employment Relations Commission. It is the administrative body that resolves labor disputes for public employees. So in Michigan, we have the Public Employment Relations Act, or the PARA as it's often called, which is the statute that governs collective bargaining between public employers and their employees. And so any allegations that actions of either a union or an employer violate the PARA are heard by the Michigan Employment Relations Commission, or the MERC. So the first case is a case called Ypsilanti Schools and Teamsters and Freeman and Harris. This is an interesting case in that this was a situation where Ypsilanti Schools had privatized busing. After several years of privatization, they decide to bring busing back in-house. So the district hires some of, but not all, of the bus drivers who at the time were employed by Durham, who they had contracted with, who was doing the busing. And then they brought back like 64 employees, but they didn't bring back all of them. 2 of them were Freeman and Harris, who were not hired and who had served as shop stewards for the Teamsters Local 243, which was the union that the drivers were under when they were at Durham. So they claim retaliation that they weren't brought into Ypsi schools because of their union activities when they were employed by Durham as the shop steward. ALJ ordered Freeman and Harris to be hired and given back pay. District argued that the MERC lacked jurisdiction, and essentially what the district's argument was, hey, how can we be punished for retaliation of union activity when any of this union activity didn't happen when they were employed by a public employer. They were employed by a private employer, and so as a result, the MERC, whose only job is to interpret the para and public employers, you don't have jurisdiction over this. And the MERC disagreed. And they said, when a public employer unlawfully discriminates in hiring paras, remedial provision allows us to order it to hire the affected applicant with back pay. So in other words, if it's being, if what they're saying is protected activity is union activity, and if your refusal to hire is based upon union activity, then you as the public employer are doing unlawful acts, even if that quote unquote protected activity occurred when they weren't employed by a public employer. So it's an interesting decision, and definitely one to think about when it comes to when it comes to sort of this sort of notion of bringing jobs back in house. Another thing that I think is important that we're going to see as a theme here, both in this case and the other cases moving forward, is for those of us who have been in the school, labor, and employment world for a while, we have been a bit spoiled. For probably the last decade, the MERC has been fairly employer friendly. And in particular for, say, probably the past, 5 or 6 years. But that has changed. There is, at least one new appointee on the MERC now, and generally, the way the MERC is structured is there's sort of one neutral, one more employer friendly, and one more employee friendly. But of course, even the employer friendly, depending on who does the appointing, which is the governor, can vary. And what we'll see here is that the decisions that are coming out of the MERC right now are not as employer friendly as many of the decisions were for the past several years beforehand. A prime example of that is the case of Garden City Education Association and Garden City Public Schools. So in this case, this deals with Schedule B positions. So district filled a vacant varsity soccer coach position by someone outside the district over a certified teacher who had applied. There becomes a dispute over this Schedule B. The union's position was, hey, past practice in the district was to give preference to bargaining unit employees to those Schedule B positions over outside folks. Here, we had a qualified bargaining unit member, and you gave it to this outside person, so therefore, you're violating that, and they file a grievance. District says, you can't file a grievance because this is teacher placement, and teacher placement decisions are a prohibited subject of bargaining, and therefore they are not subject to grievance. So again, to sort of break this down a little bit for anyone who's new in this world, a prohibited subject of bargaining is one that's specifically listed in Section 15 of the para, and they are specific topics that the legislature says are not to be bargained between a public employer and their employees. One of those prohibited subjects is teacher placement. Prior to Garden City, all of our case law had said essentially teacher placement is the broadest of the prohibited subjects. It looks broadly at this, and it is clearly meant to be interpreted broadly. And so as a result, the school district says, no, Schedule B, they're still teachers. And therefore, this is a teacher placement decision. And the MERC disagrees. And what they say is that the co-curricular position was not teacher placement, but rather one that was included in the CBA. In other words, just because it was included in the CBA doesn't mean it's a teaching position. And in this case, these co-curricular positions are not teaching positions. and it's not a prohibited subject. Now, I can tell you that I personally have some significant concerns with the Garden City case and currently have a case before the MERC where I am asking it to overturn Garden City or significantly distinguish Garden City and scale back some of the language. Because one of the big problems that I see in the Garden City case is they define a teacher based on the Teacher Tenure Act. Well, that's problematic because the language of the para specifically does not include the definition of the Teacher Tenure Act. And that's an important point because it does include that definition with other prohibited subjects. For example, teacher evaluation or personnel decisions regarding teachers. The prohibited subject specifically references the Teacher Tenure Act. And in the case of teacher placement, it doesn't. So to me, in going through this, and what we've argued now in a separate case, pending before the MERC right now, is teacher can mean a lot of things. If you look at the exemptions under the Fair Labor Standards Act, a teacher is essentially anyone who is there to provide knowledge and education, and a coach certainly does that. So we'll see where this goes, but I think this is a clear example of a MERC that is not as friendly to the employers now and is trying to rein back some of these limitations on teacher placement and on the prohibited subjects. This was, interestingly enough, a 2-to-1 decision. Did have a dissent from the more employer-friendly member of the MERC, who disagreed strongly with the opinion of the majority. So we will see where this goes. It is my belief and understanding that this case is not pending before the Court of Appeals. I know that Garden City had filed a motion for reconsideration of the decision, but last I checked, it wasn't pending before the Court of Appeals. So we'll see where that goes. Hemlock Public Schools and Emily Clayton. This is a really interesting case in that situation where a teacher engages in misconduct, including leaving the classroom unattended, posting some personal student information on social media and other things. The teacher is investigated and placed on administrative leave during investigation. She's later suspended for 3 days without pay, placed on an IDP for the following school year. She appeals her suspension, and she appeals it because they have a district policy that essentially allows almost like a grievance procedure with teacher discipline up to the board. It doesn't include arbitration, but does allow for this to go to the board to have an appeal. She also claims her IDP was arbitrary and capricious because she had already served a suspension. And there's a lot of other things that go on in the process here. At some point, she sees her file, or she asks for a copy of her file, and she says that there's discipline in there that she wasn't made aware of. At some point, her husband sends a FOIA to the district for her personnel file or for other documents, and she ends up filing this claim against the school district sort of on her own, and alleges all kinds of things, that they violated board policy, that they violated the Bullard-Plawicki Right to Know Act, which is a statute that deals with employee files and their ability to access files and such. She asserts that she had a union, or she had a meeting for her IDP, and she didn't have a union rep there, and as a result, that was a violation of the para. So she makes all these different claims. When it comes down to it, the court, or the MERC, looks at it and says, basically the majority of what you're claiming here isn't under our jurisdiction. Whether the school district violated Bullard-Plewicki or violated the FOIA or even violated school district policy when it comes to the review of the discipline, none of that is subject to the para and therefore not in the jurisdiction of the MERC. In particular, the discipline issue and the IDP issue deal with teacher discipline and teacher evaluation process. Both of those things are specifically prohibited subjects, and so they can't be part of the jurisdiction of the MERC because they can't be under the para. The only thing that was a valid claim that could have been a violation of the para was the union representation issue. And the MERC does a nice job. It's only a one paragraph analysis of that issue, but they do a nice job of analyzing, which is to say there were 2 points. One, she had this meeting to go over her IDP, and at no point during the meeting did she ask for a union rep. And so the court says, or the MERC says, first, there's no violation of your Weingarten rights. And again, that's the phrase we use based on a Supreme Court case, NLRB versus Weingarten. There's no violation of your Weingarten rights because one, Weingarten says you have to ask for a union rep and be denied to be a violation. She never asked for a union rep. There's no evidence she ever asked for a union rep. And so as a result, no violation of Weingarten. Another point, and this is a point that I think is important, I think it's missed a lot of times, which is Weingarten says you have the right to a union representative of your choosing if you ask at an investigatory interview. And what they say is there's no evidence to show that this was investigatory or an interview. This was a meeting about your individualized development plan. And so as a result, the fact that they didn't supply you with a union rep or get one for you is not a violation of Weingarten. Okay, so those are the MERC cases we're going to discuss today. Before we move into the last couple of things, a question did come up, which is the Sixth Circuit case granting the professor First Amendment protection for using the wrong pronoun for the transgendered woman being appealed to en banc or U.S. Supreme Court? So that we all understand that question, en banc means when you're at a federal appellate court, the case is heard by a 3-judge panel. There is the right to appeal that decision to an en banc, which means the entire panel of the Sixth Circuit, which means all 12 or 14 judges, however many are sitting at that time in the circuit, hear the case and they make a decision, and the majority rules in that case. In this situation, I believe that case, there has been a petition for certiorari filed with the U.S. Supreme Court, or a petition to hear that case by the U.S. Supreme Court. I believe that's where it's gone, but I can't say that I'm 100% on that versus an application for en banc hearing. But we will see where that one goes, because I do think that case is going to be one of interest, nationally, and not just in the school world, in the K-12 world, but of course, in general, I think it's going to be an important case to help define some of the bounds of religious freedom, which has become more and more an important and discussion point in society right now. Okay, independent contractor rule. This one isn't quite as big of a deal in schools as it used to be. And to help understand what I mean by that, there is a difference between independent contractors. Sometimes we think of independent contractors and we think of employees of third parties that are working in our facility, your EduStaff employees or et cetera. Those employees aren't actually independent contractors. They're employees of, they're contracted employees. They're employees of a third party that we've contracted with. An independent contractor is generally more to think of as an individual who we make a contract with to come in and work in the school district. This was a far more common practice pre-2010, before sort of some retirement rules were modified, when school district administrators or people within a district would hit their 30 years, they would retire, and then they would contract back with school districts to do mostly the same work oftentimes, but now as a retirant rather than as an active employee, and they would contract back. That has changed because of some modifications to the retirement law, and not because of the federal rules. So we don't have as much of that. We still do have some, though. Right, under the retirement rules, people can contract back directly or be employed directly with schools and make 30% or less. There's also some different ways in which we have independent contractors in various forms. So there is still some of this. In I think it was in 2019, the Department of Labor issued some new rules on independent contractors. And essentially, this was to deal, I think in large part, with some of the concerns that were going on with your Ubers and your Lyfts of the world, right? Your Grubhubs, or these places where we have all these sort of gig workers that are considered independent contractors. And the rules took the case law that was out there and synthesized it a bit and made it, I would say, a bit easier than it had been, or suggested that more people were independent contractors than maybe would have been interpreted by some under the law at the time. And by doing so, they focused on sort of two core factors, which was the nature and degree of the control over the work, and the worker's opportunity for profit or loss based on initiative and or investment, which is an important distinction, because what oftentimes courts would say is, well, opportunity for profit or loss based on initiative isn't important, meaning it can't just be if you work more, you make more, or you work less, you make less. That's the same as an employee. Instead, it has to be based on investment or business acumen, etc. And so the Fed said, no, we're going to focus on these two things: nature and degree of control over the work, meaning can they work independently, or do they have somebody overseeing and supervising all of their daily tasks? And then secondly, what's the opportunity for profit, which would include making more money by having more initiative and by working more. The current administration came in and has now withdrawn that independent contractor rule and gone back to what was the old standard before those rules, which is to look at this in more of a holistic fashion. It has 6 factors now. Well, it still had 6 factors, but the DOL said there are 6, but these are the 2 biggest ones. And now the Department of Labor has said, no, we're supposed to look at a totality of the circumstances and the whole and all of the factors, and not parse out 2 that are more important than the others. And so as a result, that's now been pulled, and those are no longer effective. So we'll see if the DOL puts out any new regulations on that, or if they're just simply going to go with the case law and let it roll from there. Another one is an EEOC guidance that recently came out on religious discrimination and accommodation of religious beliefs. As I mentioned before, this has become increasingly over the last number of years a hotter and hotter topic, right? You think of Bostock that came out, and the case we discussed earlier, the Sixth Circuit case. You think, going back to the case out of Colorado with the cake baker, and these issues that have been coming out more and more over the years about sort of where the bounds are on religious freedom and religious discrimination by employers. And so in January, the EEOC, the Equal Employment Opportunity Commission, which is the federal agency whose job is to enforce several laws, including Title VII, which, as we talked about earlier, is a federal anti-discrimination law that includes not only sex, but also race and religion as well. So the EEOC issued guidance on religious discrimination and accommodation, which clarifies judicial, legislative, and policy actions taken place since 2008. As they say in the regulations, and they talk about in terms of the guidance, that the EEOC has dealt with a surge of Title VII charges alleging religion-based discrimination in the since 2008. And since 2013, there's been a steady increase in EEOC sexual orientation and gender identity discrimination charges. So we have sort of, again, as I mentioned before, the collision of these two issues and an attempt to determine where the bounds of these two issues are. In 2015, the EEO determined that sexual orientation discrimination is discrimination based on sex. So even before the Supreme Court had, the EEOC had come out and said in 2015 that discrimination based on sexual orientation is discrimination based on sex. The new guidance talks about how an employer can reasonably accommodate an employee through flexible scheduling, voluntary shift swapping, or lateral transfers to enable religious observance and accommodate religion. An employer can modify workplace practices, policies, or procedures. An example that the EEOC gives is that an employer could accommodate a pharmacist who had a religious objection to dispensing contraceptives by allowing a coworker to assist customers who seek to make those purchases. So this is an example, and again, this is an example of where we're seeing sort of this extension, or at least an attempted extension, of religious freedom into secular environments and workplaces. So, they give this example that, a pharmacist has a religious objection to dispensing contraceptives. They could call over the assistant or another pharmacist and have them do that work rather than having the pharmacist who objected. What the EEOC doesn't get into as much is that, it says that an employer could accommodate, and where I often have trouble with federal agencies is that their guidance can be a little bit mushy, which is, well, okay, that's great that they could, but do they have to? Do they have to say, yes, pharmacist, you don't have to dispense contraceptives, and instead we will make this accommodation. Another example that's given within the guidance is, from a accommodation standpoint, if I have a religious objection, let's say again to sexual orientation issues or LGBTQ issues, and the employer is having Pride Month shirts that we're going to wear, and I have a religious objection to that, can I have the accommodation to not wear my shirt or not wear that shirt? And the court says yes, or the EEOC, the guidance is yes, you can make that accommodation. Again, I think where we're going to have to figure this out over the next several years is the bounds of when you must. And so when considering an undue hardship, which is the standard that an employer has to show if they're not going to give an accommodation. So in other words, just like we think about with the ADA, when an employee with a disability asks for an accommodation, we have to think, okay, before we say no to the proposed accommodation, is there an undue hardship? and the EEOC says the factors when assessing undue hardship for an employer include the identifiable cost in relation to the size and operating costs of the employer, and the number of individuals who will in fact need a particular accommodation. Again, an example is if an employee does not want to wear a uniform supporting LGBTQ rights on religious grounds, employer can reasonably accommodate the employee without undue hardship by permitting the employee to opt out and partaking. However, the employer can require the employee to attend diversity training that fosters respect for others. So again, the question there comes up, and this is, of course, the diversity training issue was a big one over the last couple of years, with the last administration sort of objecting to the notion of some diversity trainings. And so in this case, what they say is that diversity training is not in and of itself any violation of right if we're just talking about fostering respect for others versus having to accept things that maybe, for example, somebody is religiously opposed to. Another point I think is important to understand, and this goes again sort of similar to ADA, is oftentimes when considering undue hardship, if a particular requested accommodation is an undue hardship, does that mean the answer is simply no? Sometimes what we can do, and under the ADA this is very clear, and I think under Title VII we can do so as well, is we can suggest other potential accommodations, right? So it isn't necessarily we have to go with the accommodation the employee requests or no accommodation at all. Instead, if there is another accommodation that can be made, that would allow for the employee to not violate their religious freedom, but also move forward without an undue hardship, then we can work through and try and discuss that as well. Question was asked, so if an employee refuses to refer to a student using the preferred gender, justifying it as a religious belief, that is acceptable and not subject to discipline, even though the student continues to complain. That's the question being posed, and I would say that isn't that clear at this point. The case in question that we talked about before has not made that clear, and I think again there are two main parts. One, the First Amendment issue in that case, again, dealt with the university academic freedom issue, and I don't think that applies at the same level at the K-12 setting. Secondly, when it comes to the free exercise issue, the court in that Sixth Circuit case focused less on the free exercise of the usage of the pronouns, but rather in the school district's refusal to even consider an accommodation for the professor, and really the fact that they showed hostility toward his religious beliefs for even asking for the accommodation. That was really where the Sixth Circuit focused on that case. So I am not prepared to say that if you have a teacher who says, I'm not going to use preferred gender pronouns, you have to allow them to do that. Because I don't think that that's what that case stands for at this time. I think we're still figuring this one out when it comes down to it. And I think this is still an issue that's going to be litigated quite a bit. And what I would suggest is if you have that scenario where you have a teacher, you have an employee who says, I am not going to call this individual by their preferred gender pronouns. I'm going to call them based upon their biological sex. Then I would call your lawyer and talk through the situation and how to handle it in that scenario, because at this point, we don't have a clear answer yet coming from the courts. Do I think this is one that, say, in the next 5 years, we probably will have a more clear answer? Yes, I think we probably will at some point in terms of trying to figure out where these bounds are, but we don't yet. So I know it's a very lawyer answer and then it's a non-answer, and I'm sorry for that, but that is the reality at this time. So if there are any other questions, I would be happy to answer those at this time if you want to throw them in the chat. And I will give a minute or two for questions in case anybody has them. If not, I can say that it was a pleasure to be able to be here giving the legal update for MASPA. It's always an organization that I appreciate and all they do for the folks here in Michigan. And thank you very much. I don't see any more questions coming in. So with that, I will bid you all a good day and enjoy the rest of your week. Thank you very much.
Thanks, Bob. We appreciate your partnership and your help as well.